You can sue for pain and suffering in New York, no question about it. There are some rules and regulations that you have to go through because New York is what they call a no-fault state. No-fault basically states that you will get paid for your medical bills and your lost wages even if the accident is your fault. But if the accident is not your fault, while you also get paid for your medical bills and your lost wages through the no-fault insurance coverage on the car, you could still bring an action for personal injuries if you meet certain criteria, and they're pretty easy to meet. But I want to make one thing certain. Some people don't go to the doctor even though they're in pain because they don't have medical insurance. If you're involved in an accident in a car, the car will have medical coverage for you for that accident. So whether you're the passenger or the driver, whether you're the pedestrian, that car will have coverage for you if you're in an accident. And you don't have to worry that you don't have medical coverage. And that medical coverage is not a lien on your case, up to the first $50,000. And so $50,000 of medical coverage and lost wages in combination. So you need to have a serious injury, what they call a serious injury under the law, in order to bring a lawsuit. But there's a lot of things that qualify for serious injuries, such as fractures, disfigurements, a loss of a pregnancy. If you had limited use of your hands or your legs, or you weren't able to walk, for example, or you weren't able to use your hand because there was pain when you go like this. Full or partial disability for at least 90 days out of the first 180. For example, if you're out of work for 90 out of 180 days, you qualify. Of course, a death case would qualify. And there's all kinds of ways that a lawyer could show that you have an injury that qualifies under the law.